Senator Waters.
Thank you, Chair. Hi, folks. Thanks for coming along today. Both the Law Council of Australia and the Chief Justice of the Family Court have expressed serious concerns about the impacts of the cuts to legal aid funding. Could you please talk us through, from your experience in the Family Court, what those funding shortfalls will mean for women and their children subjected to violence?
Well, I'm not really certain how I can actually respond to it.
Well, I think that's really a very open-ended question, Senator. I mean, you can't ask an official. It's not fair to an official to ask him to be a commentator on government policy. I mean, these budget savings were forced upon the government, as you know, by the previous government, and they will obviously, self-evidently mean that there are less resources available to certain functions of government, including these witnesses as well. But it's not, I think, fair to ask them to make a kind of a general political comment and
with respect
or to assume a causality either, by the way.
With respect to Attorney, perhaps I can clarify my question.
Sure, I'm just inviting you to do so and to narrow it perhaps.
If you'll allow me to do so, thank you. In your experience as administrators of the Family Court, to which women and families seek justice through your court, what effect, in your experience, will the reductions in legal aid funding, including to women who've been subjected to domestic violence, have on their ability to access justice through your court? How will it change things?
Is this specific to women and children or to everyone?
To women and children facing domestic violence.
Know that, as opposed to a general reduction, anyhow.
Why don't we, let's answer it to the best of your experience.
Yeah, it's a pretty difficult question for me to answer with any great clarity, but I mean, all I can say is that I think any reduction in legal aid will have some sort of impact on the amount of representation. But there are a number of other organisations that have been established to provide advice. There are community legal services at the courts. There's information on websites all over the place. We have, the courts have run many or unrepresented litigant projects providing more information. There's information on YouTube. There's a family law assistance program been running in Dandenong, which impacts directly on the people coming to the Federal Circuit Court in Dandenong. So there are a range of other organisations other than legal aid themselves who provide advice and assistance to people who will end up regrettably in the family law courts system. But at the end of the day, I mean, I think it follows the event that any reduction in funding anywhere is going to have some impact on the people who provide the service.
I should add, Senator Waters,
Go ahead.
that it's not at all it's not at all clear that it's right to say that there's been a reduction in legal aid funding available to family law litigants. There have been some reductions, there's no doubt about that, but there's been an increase in the aggregate proportion of legal aid funding to litigants. I don't know how many times I've had to say that in this estimates. The reason numerous times, but it's directly responsive to your question. The reason I made a decision that I wanted to spend all of the legal aid money on casework is to prioritise the concerns of litigants in vulnerable circumstances, and the two major categories are family law cases and also criminal cases, but the largest of all is family law cases. And much as worthy work is done in policy and advocacy, and much as there's been criticism of defunding environmental defenders offices, for instance, and I know you're interested in this issue.
I am, but not in the family court session.
Yeah,
and I have limited time, Attorney.
This is my point, Senator.
Please make it succinctly.
This is my point, Senator Waters. You can't, on the one hand, say, well, you shouldn't have reduced the funding to family law litigants,
Attorney,
and on the other, and at the same time,
and I'm seeking to
and at
hear
the same
from the
time say, you shouldn't have failed to prioritise casework. The decision to prioritise casework is to get more money to family law litigants and people
If
like
you could
them,
just
not
allow me
less.
to question the official's attorney, that's precisely what I'm seeking to ask about. Am I correct, before we had that little interlude, am I correct in that you're saying that the reductions to legal aid will have the effect that there will be more self-represented litigants before your court? Or perhaps in addition to that, is it your experience that women will in fact withdraw their applications for justice to your court? That's what I'm trying to get at.
But you're assuming there's a reduction of legal aid funding to family law cases, and that is not established.
Well, I am assuming that.
Well, your assumption is based on a guess that when the
Well, my assumption was based on my understanding of the budget and that there'd been
No,
a
but
$15 million
the
cut
budget
to
talks
legal aid
about
funding.
some reductions to aggregate legal aid funding. That's true. I don't dispute that. That was forced on us by the previous government.
And that won't have any effect on women?
But Senator, that legal aid funding used to be spent on a greater variety of causes than it will be now.
So are you guaranteeing that's not going to come
I'm answering your
from
question.
women?
100% of the legal aid funding from a slightly reduced pool will be spent on casework, of which family law cases are the largest component, whereas under the previous government, less than 100% was spent on casework, of which family law cases were the largest claimant. So
are you guaranteeing that there is no reduction in funding to family law casework as a result of the slightly reduced pie, as you call it?
What I'm guaranteeing is that family law matters and frontline services, what I generally call casework, will be absolutely prioritised, so that if there's an effect, and it's by no means clear there'll be any effect,
Well,
if there's
that's
an
your
effect,
job to answer.
that effect
Is
will be
there a
mitigated.
reduction or not? It should be clear. You're the Attorney General.
But this is a matter of arithmetic, Senator.
Yes, I'm asking you to answer. Is there a reduction?
If you shrink the pie, but within the shrunken pie you increase to 100%
Yes.
what is going to one particular recipient,
Yes.
then it does not at all follow that the amount going to that particular recipient is going to be less.
Which is why I've asked you the question, will it be less for the case of women seeking to access the family court?
Well, we'll have to see. We'll have to see the way...
With respect, you wrote the
way
budget,
this
Attorney.
operates.
Is it a yes or no? It's not a will, we have to see.
We'll have to see the way in which this operates, because demands on the pool of funds, as you know, fluctuate from time to time. They fluctuate between categories of cases. But what I'm guaranteeing to you is that 100% of the Commonwealth's money is going to be spent on frontline services.
Okay, well, given
I
we
can't
have
do
the
better than
officials of
100%,
the
Senator.
family court here, I'd kind of prefer to hear from them, since we have a limited opportunity to do so. I can talk to you any old time,
but you're asking them
Attorney
a question
General, and I
they can't
wait
answer.
for that. So,
You're asking them a question that it is not possible for them to answer, and it's not fair to them.
in your experience, is the level of self-representation, which is influenced by the level of legal aid funding provided from time to time by the government of the day, what impact does the need to self-represent have on female applicants to the family court in terms of whether or not they sustain their application or whether they withdraw it?
I just couldn't answer that question, Senator. I have no idea.
Do you not collect statistics on the effect of self-representation on whether litigants pursue their application?
Not specifically, no. I mean, we know when people withdraw their application, whether that's to do with legal aid or not, I'm not entirely certain. I think that's a research project would be outside the capacity of the court to do, I would think. I mean, it's quite a complex question that you ask. And
Are you aware of anybody's looking at that? It does seem to be a relevant question.
Well,
of the
I
impact.
can answer that question. The Institute of Family Studies is the body. It's not the only one, but the Institute of Family Studies is one body that looks at these matters. The Family Law Council is another. The Family Law Council actually some years ago conducted a study on unrepresented litigants in the family court. And I'm not sure if you were in the hearing room when I said this a little while ago, but a few weeks ago I had a meeting with the chair of the Family Law Council, and we are considering giving them a new reference to conduct an updated study on unrepresented litigants in the family court and their needs.
Excellent. You're considering that. Can I
Yes.
ask what the timeframe for the decision on that is?
It'll be quite soon.
Okay, and will that come with additional resourcing?
No, the family law court is already resourced.
No, you're talking about the Institute of Family Studies, are you
No,
not?
no, I mentioned the Institute of Family Studies and the Family Law Council.
Sorry, so who will be charged with possibly
The discussion
conducting
I
this
had was with the
possible
chair of the
study?
Family Law Council.
And will they be provided resourcing to do that study?
No, because they're already resourced.
And what work will they not do as a result of doing this good
None.
work?
None.
Okay, are they a magic pudding or a council?
No, because they a bit like the Law Reform Commission, they from time to time undertake bodies of work.
Good, well, I hope that proceeds. Can I attempt to ask the officials some questions?
Ask the officials questions if you like, Senator. But
That is the point of estimates, so thank you, Attorney.
No, actually, the point of estimates is to ask questions of the government, and technically every question is to the minister.
Well, I'm sure you're
Technically,
having a lovely time, but I would
not
like to
particularly.
avail
Every
myself
question
of
is
the
to the minister.
expertise of the family court officials here,
please
if I
don't ask
may.
questions. Please don't ask questions of officials that embarrass them because they're not in a position to answer them. And if you want to know the policies
I'm sure
of the
they're
government,
big enough to
please ask
answer
me.
to the extent of their expertise, but thanks.
I'll
Thanks.
listen more carefully. Senator Waters.
Thank you, Chair. In relation to access to justice for women in regional areas, can you talk about the effect of the, what I understand, and I'm sure the Attorney will correct me if I'm in any way mistaken, the reduction in hearings in regional areas of the family court since 2008?
The primary responsibility for circuiting in rural and regional areas lies with the Federal Circuit Court, and the Federal Circuit Court extensively circuits to all parts of Australia, with the exception of the Western Australia, which is serviced by the Family Court of Western Australia. The Family Court of Australia, because of that change in role, if you like, stepped back from running regular circuits to rural and regional Australia, but there is a commitment by the court to attend anywhere in the country where there's a case that demands the presence of a family court judge and on a special fixture. So if the Federal Circuit Court, for example, identified a case that required a Superior Court judge to hear it, then the Chief Justice of the Family Court would provide a judge to attend at that location and hear that particular matter. That's the arrangement that's in place. So the Family Court doesn't, because it doesn't have to, regularly circuit to all parts of Australia. That's a role undertaken by the Federal Circuit Court. But yes, it still will attend rural and regional areas for special fixtures for cases that require the attention of a Superior Court judge.
And how would an applicant know to make such a request? Are there information services available so that...
Well, that would be an assessment made by the Federal Circuit Court judge. It would be up to that person to say this is a case that should be transferred to the Family Court. And that happens both not in rural and regional, but it happens throughout the whole system. There are matters transferred between the two courts. If there's a matter comes before a Federal Circuit Court judge who thinks that this is a matter more appropriately dealt with for whatever reasons in the Family Court, and that matter is transferred to the Family Court.
Okay, so would that require two hearings, say, for example, rather than just one?
Well,
I'm thinking of the burden on the applicant to be able to get there, for example, and of course the cost to engage the legal team for the day, unless they're sadly self-represented, which unfortunately seems to be not studied by your court.
I'm not talking about a trial being put off, and these things are done as a preliminary arrangement, so it's more like a directions hearing or something. So
sure, which still entails a court hearing.
They'd be there anyway for that process, and you're not necessarily going to get a trial on the day that you first appear in court. There's a whole lot of other processes that you need to go through. So I think it's an extravagance to probably say there's an extra appearance required. I don't think that's right
Look,
at all.
I will put some questions on a notice because I do want to understand this,
sure.
but am I correct in that rather than having direct access to the family court in regional areas, that there is now an additional step where an applicant will have to go through the Federal Circuit Court, have a directions hearing, be told that actually, no, you do need that other court, and then have a second court appearance? Is that correct?
Right. That's not
You can still make application to the to the Family Court directly, but if it was a matter that the Family Court considered was a matter that should be in the Federal Circuit Court, then it would be transferred back to that court, and vice versa. That's how the system
I'm talking
works.
about matters that belong in the family court.
Yeah, well, you can make there's a protocol between the two courts, which I haven't got with me, Senator, but I'm quite happy to provide to the committee, which is
Okay, so
largely
can I
adhered to,
confirm
which
then-
provides for litigants to decide which is the most
Sure.
appropriate court they
So
should
can I
file in.
confirm then that the family court will still make those regional trips
Oh, the
where the
Chief Justice
workload
stated
determines?
that as a policy of the court, that the family court, if there's a matter that's identified that requires a superior court judge, a family court judge to hear it, then the Chief Justice will provide a judge in that location to hear that matter.
Okay, and there won't be any sort of cost considerations, that will happen as a matter of course?
Yeah, the judge will go there.
Well, thank you for clarifying that, because I had a contrary
Well, it was
understanding,
never
so I
unclear,
appreciate that.
Senator. You seem to be implying that
Well,
there might
perhaps
have
your
been
friends at the Australian
some
might need a
change.
phone call from
It
you,
was-
Senator
it was
Brandis,
never-
because
it was
it's
never
in today's
unclear.
paper.
So what Mr Foster has told you is as it is and as it has been.
Well, it was reported differently today in perhaps your newspaper of choice, The Australian, and hence my line of questioning. I'm really pleased to have it clarified that that was inaccurately reported. Fancy that in The Australian. Thanks, everyone.
All right, thanks. Are you finished, Senator Waters?
Chair.
Thanks, Senator Waters.